SJC-11876, Commonwealth versus Kyle Johnson.
Good morning, Ms. Burbine.
May it please the Court, Carolyn Burbine for the Commonwealth. This is the Commonwealth's appeal, and our position is that the judge was not warranted in granting the defendant's motion to suppress, where he erroneously deemed the victim's identification of the defendant from a single photograph shown to the victim by the victim's cousin especially suggestive, and therefore inadmissible at trial and tainting any subsequent identifications.
Could I ask you a procedural question? I should know what it says in the rule, but with respect to the argument of the defendant, which was this wasn't it wasn't police conduct that made it suggestive, but other. Did you take a position below, or do you take a position now that it wasn't even required to have a hearing? Or, in other words, hearings are often triggered, usually I think, triggered by a claim on the defendant's part that the government has used an unduly suggestive procedure. So it's state action.
Right.
And here we're talking about private action.
But under the common law, where we have this highly suggestive.
Right. It's really a procedural question whether it ever came up.
I don't believe that we ever said there shouldn't be a hearing. I believe we just had the.
So you have no problem with where a defendant makes a claim such as this, that it's going to trigger an evidentiary hearing?
If it's the judge's discretion. If the judge believes it warrants a hearing, then I wouldn't say the judge didn't have the discretion to make that. If the Commonwealth argued against it, and I would say that's within the judge's discretion to still determine that it warranted a hearing.
Now, you say the judge erred. What is our standard to evaluate whether the judge erred? Is it abuse of discretion?
I believe it's abuse of discretion, yes, but it's also, we believe he erred because, as a matter of law, because he relied on Jones, and it's our position that Jones does not apply.
I couldn't hear what
I'm
you
sorry.
said.
Now, I have to think of what I just said. It's our position that he erred in that he relied on Jones, Commonwealth versus Jones, and we don't believe, as a matter of law, that he properly applied Jones to this case.
And why is that?
Jones requires that the identification be highly and especially suggestive. And in Jones, you had a situation where the witness had a brief opportunity to observe an African-American defendant at a motel where two of the perpetrators of the crime, who were Vietnamese, were staying. The witness had seen the Vietnamese man at the motel and knew the crime involved a robbery by a Vietnamese man and an African-American man. And then subsequently, 2 times, she was in the courthouse through no doing by the Commonwealth during proceedings in this case, where she saw in that same room the defendant was shackled to a Vietnamese man, and he was the only African-American man in the courtroom. And she was in the courtroom one time for over an hour. And the court held in Jones that implicitly the circumstances indicated that the prosecution thought the defendant was involved in the crimes. So under these circumstances, the identification was inadmissible.
But why isn't the Jones standard still the standard?
Jones is still the standard. I'm not saying Jones is not the standard. I'm saying
that an abuse of discretion question?
I'm saying that the judge should have looked at Jules and looked at the neutral surroundings. And he just took Jones, which it is the law, it's the applicable law, but I feel that he misapplied it because he didn't take into account Jules. And we had done a motion to reconsider based on Jules, which he denied in the margin.
Well, I guess but the question is that an error of law, or is that his findings of fact you disagree with? So it's an abuse of discretion.
I see what you mean. I see. Abuse of discretion would probably be correct then.
I mean, he found that it was highly suggestive and
right.
that it was unreliable.
Right.
Those are fact findings, really.
That's correct. So I'll amend my position on that. I apologize.
So, and again, and that invites the question of why was it an abuse of discretion. He gave a very vague description of the attacker. He said he was light-skinned, and the judge looks at him in the courtroom and says, he doesn't look very light-skinned to me. And then he has this strange situation where this fellow in Roxbury says, we have a videotape of somebody burglarizing my home. This may be the guy who burglarized your home in Brockton, and sends a photograph of him with the girlfriend, who I guess is the cousin of each. And so why is it an abuse of discretion for the judge to say that the cousin suggested that this was the same guy who burglarized his home, and that he's sufficiently concerned under these circumstances that I don't feel comfortable saying that this should go to the jury?
Because I think after the Commonwealth pointed out Jules to him, he should have also taken into account the fact that these were neutral surroundings. It's like the picture in the newspaper. And in Jules, you had a woman who saw a man in the street nearby where the victim's body was found. She commented to her husband how she doesn't usually see people that early in the morning. Then 2 days later, her husband says, "Oh, did you see the newspaper?" And there in the newspaper, on the front page of the paper, she sees a picture of the defendant in handcuffs. And that was not deemed by the court to be highly suggestive. So I
Well, I'm
would
sorry.
posit that
The judge, I mean, I'm trying to recall that case. The judge in that case said that I am going to admit the testimony, correct?
the testimony, I believe the trial had already, she had given it at trial. This was a post-trial.
Right, so, but it was allowed
So
in.
It was allowed in, correct. But
And the question was whether
It was
that
highly
judge abused his or her discretion to allow it in.
But it was the point is the highly suggestive standard. And here, I would say this was not highly suggestive because the victim viewed the photo in neutral surroundings. The cousin told him his apartment had been broken into.
He's neutral surroundings, but he's looking at one picture.
That's correct, but it's not a situation like in Jones where you're in the courtroom and you see someone shackled to someone and you
But he's,
you have the impression that the prosecution believes that this person was involved in the crime. Here we have the cousin saying, hey, my apartment got broken into, and I think the perpetrator might have been the defendant based on the defendant's size and shape.
yeah, but the defendant is
It's-
related to both, yes, the defendant is.
No,
is
he's not
the
related.
He's the boyfriend of.
Their
The
cousin.
cousin of both of them.
Right.
Both the Roxbury, Mr. Hendrick and Mr. Talabi,
Right,
correct?
and yes, and the photograph is from a cookout. It's not a person in handcuffs, it's not on the front page of the newspaper, which,
You don't think that the whole circumstance by which the photo, what Mr. Hendrick said about what he observed and the going down, you don't think that's suggestive?
no, because he said he thought it might be, that the cousin wasn't in any way even suggesting that I think it was him. He just says, hey, I think it might have been. He didn't say, I know he did it, I'm sure he's the one that broke into my apartment. So I would say that that's neutral circumstances. And I would also point out that this wasn't a situation where the victim would have felt pressured by the cousin to make an ID. The robberies were in different towns, different counties. Nothing the victim said about his own case would affect the cousin's case. And also, there was never any indication of any animosity between the victim, Hendricks, or the defendant. So you don't have...
We don't know that, do we?
There's no, the defense didn't put anything on about that. There's no indication of it. There's nothing in the record to indicate any animosity. And the police officer who testified, she did not testify to any comments that indicated any animosity. It was just...
The police officer from New Bedford? Or
From
Fall River?
Brockton.
From Brockton? I'm sorry. I mean, okay.
The conversation, she had a telephone conversation with both
Oh, yes.
the victim
three-way
and
conversation, right.
the cousin. And so there was no indication from her testimony that there was any animosity. It was just, so I would posit that this is akin to Jules, where, and even less so, because in that case, in Jules, you had the defendant on the front page of the newspaper, which means that you've done something, in handcuffs. And while she testified at the trial that she did not read the caption or the wording underneath that indicated it was a brutal stabbing, et cetera, you still had a photo of someone in handcuffs on the front page of the newspaper. And and in that case, that was not held to be highly suggestive, so I would posit that here as well. the cousin saying, I think it might be him based on his size and shape, not even, oh, he looks just like him, anything like that. I just don't see that it's enough to taint it so that it would be inadmissible, and also enough to taint it so that the photo array, which the defendant did not claim was unfair in any way, and which the judge found was not unfair in any way, should also be. I feel the judge also erred in barring that and any future in court, because he's taking everything from this idea that that first photo ID could not have been independently, that it has to have tainted the defendant's initial.
Was there a reason
viewing.
why the photo, either the array or the photo in question, or these two witnesses didn't testify?
I don't see an explanation in the record as to why the two witnesses testified.
Did the Commonwealth go first?
Excuse me?
At the hearing on the motion, did the
The
Commonwealth
hearing on the
go first?
motion, when I read the hearing transcript, I don't see any discussion as to why neither party called the cousin, or I just don't know. It's not on the record. I do see the prosecutor. There's a discussion with the prosecutor saying, I'm not going to put in the photo array because, as I understand it, there's no dispute as to the array, and defense counsel agrees. So that's why the array doesn't come in. There's nothing on the record that I see to explain why neither side called the.
But we don't know if the picture that was shown by the cousin was in the array?
We don't. There's nothing.
We do
No, but I
know
would
it-
assume, I think that we can infer that defense counsel would have likely have contested the array had that been the photo that the police officer used. But because we don't have the array, we can't, and we don't have the photo from the cookout either.
I mean, based on this record, the judge said the police did nothing wrong.
He said they did nothing
And I
wrong,
think we
which
can infer that
implicitly,
if the police had used that same photo, the judge would not have made that finding.
that's correct, Your Honor.
Just out of interest, because this is, I forget the year, 2010 or 11 or 12?
I think
Anyway,
it was,
there's no sequential array, or what is Brockton doing?
it's because the array didn't come in. The only testimony about the array was the officer who showed the array to the victim was not the officer who prepared the array. He read, I forget the name, witness protection form. He read from some form when he
I think it's just
presented
one
the array,
sheet.
and it was 8 photos on one sheet, I believe. And I believe that's
Just
the
was
only.
interested in Brockton, the City of Brockton Police Department's policies about photo ID. You don't know?
I'm not sure what those are, Your Honor. It wasn't in the record. Did the court have any other questions? I would just, regarding the amicus, I would urge the court that in the circumstances of this case, no change in the applicable law is warranted, and that the judge's ruling should be overturned.
All right, thank you.
Thank you, Your Honors.
Good morning. Edward Crane on behalf of Kyle Johnson. It is the defendant's position that this court should adopt the study group's recommended standard with respect to excluding unreliable eyewitness identification. This standard is on page 111 of the study group's report, and it states as follows: where the defendant proves by a preponderance of the evidence that an eyewitness identification is unreliable, taking into account the totality of the circumstances as well as system and estimator variables, the out-of-court identification and any in-court identification should be excluded. Adoption of this standard would answer both of the questions raised by this case.
So I should remember this, and I don't. Did the judge find that it was both highly suggestive and unreliable?
I believe the judge did. He never explicitly states in his opinion that it was unreliable, but he states the language from Jones, which speaks to unreliability, and then he says, under Jones, I find that he excludes it under Jones, under the rationale of Jones.
Because doesn't the study group's recommendation, and I could be wrong about this too, but it makes a distinction between highly suggestive and something being suggestive and unreliable, doesn't it? In other words, if it's highly suggestive, doesn't the study group say then the Commonwealth could prove by clear and convincing evidence that there was an independent source for this identification? Whereas if it's unreliable, you don't get that second bite at an apple, at the apple.
Yes, I believe the study group does say that, but that is in the context of a highly suggestive identification that involved law enforcement. With respect to an unreliable identification, the study group's report is essentially that the unreliable identification, as well as any in-court identification that follows, should be suppressed.
But I do think there is some distinction between something, even taking state action out of this, that there can be a distinction between something that's highly suggestive and unreliable.
I think so too, and I think that with respect to both of those, I think where they interact is suggestiveness is essentially a factor that should be considered in the overall assessment of reliability. I think that suggestiveness, and I think that was the overall intent when the test originally went into place, is, look, suggestiveness speaks to a lack of reliability. So I think that suggestiveness is just one factor that should be considered in the test for reliability.
But first of all, you don't need to we don't need to do that here, do we? I mean, here the judge found it was suggestive and unreliable.
Well, that's the question.
So why would we use this case as opposed to a case where there was no suggestion, but the person identified somebody from 100 yards away and said, that's the guy, to be the vehicle to determine whether or not we can abandon the suggestiveness prong as part of the Jones test?
Well, in all honesty, I speak to the amicus announcement, and if the court finds that this is not the right occasion to do so, then it's not the right occasion to do so. I feel like it could be in the sense that, look, if this is just an unreliable identification, then that question's before the court. But I would say if the court feels like this is the time to change the law and make it so that we are focusing on unreliability, then I think obviously that's up to the court's discretion. And I think that this decision by the judge is completely defensible without changing the law. It's defensible just based on Jones.
Did the judge say that you can't put in the photo array, you can't have an ID in court, and you can't have the array from the sending, the aunt's sending or the grandmother's sending? In other words, all three were out. Is that part of the decision?
Yes.
I should remember this. I don't.
Yes, he excluded all three IDs.
Basically because the Commonwealth did not prove by a clear and convincing evidence that there was an independent basis for the identification.
Yes.
All right. The way the judge characterizes our holding in Jones is that common law principles dictate that an unreliable identification arising from especially suggestive circumstances should not be admitted. So it's essentially not that the witness is inherently unreliable, but the circumstances are so suggestive as to create an unreliable identification, right?
Yes.
And that's sort of what the judge concluded here.
Yes.
Totality of the circumstances were so suggestive, it created what he concluded was an unreliable identification.
Correct.
Okay. So that would be the standard. Are you suggesting we change that standard?
Well, I think just with respect to the amicus announcement, with that question that was posed, I would state that really suggestiveness shouldn't be a prerequisite for excluding an unreliable identification.
Well, there's two pieces here. You could say something, it was not a suggestive procedure, but the witness is so unreliable that I'm not even going to allow it in. And the other side of the coin is the circumstances were so suggestive, whether he would otherwise be reliable or unreliable, I'm not allowing it in. Here, this is sort of a twofold piece. Unreliability arising out of very suggestive circumstances.
Yes, and I think that essentially the position that the study group took was essentially that suggestiveness is not necessary for a ID to be unreliable. And unreliable identifications are really what we're trying to get at here. Suggestiveness speaks to lack of reliability, but there can be unreliable identifications that result from non-suggestive circumstances, and there should be there's an undue focus on suggestiveness, when suggestiveness is simply a factor. It's a strong factor, but simply a factor that should be considered in the reliability analysis.
But that was the basis of the judge's finding. The judge said, under the facts here, I find that both of the out-of-court photographic identifications of the defendant were impermissibly tainted by the suggestive circumstances.
Yes.
But doesn't, I mean, wholly apart from whether there might be a non-suggestive, unreliable identification which should be suppressed, doesn't suggestion matter in view of the fact the study group found that it may affect the testimony in two ways, both with regard to the degree of certainty and also with the person's description or memory as to what occurred? That when a person is suggested that it's the culprit, not only is the person going to be more confident about it when he or she testifies at trial, but also his memory as to how long he saw the person, how well he saw the person, all that may be altered. And isn't that a little bit different from a pure unreliable observation, which may be that he was just so far away that one can say that one cannot reliably identify somebody from that distance? It doesn't necessarily affect the certainty or the description of the events, but suggestion would. So isn't there a difference?
Absolutely. There's a difference in that the suggestiveness, again, it speaks to reliability. I think in this case, I guess, the suggestiveness is just, it makes this case even stronger. I mean, I think that, I think we're looking at sort of a hypothetical, like what would be the result in this case if not for the suggestive aspect of it? And I think really in this case, the suggestiveness is a factor, and the judge considered it, and it should be considered in all future analysis of an identification. But it's a factor that should be considered in reliability. And again, this comes down to, well, is this the case to make this ruling in? To make the ruling, should we be waiting for a case where there's a non-suggestive identification that other factors indicate that it is unreliable? Should we wait for that case? And I think maybe that's what we're getting at here. Simply, in this case, the suggestiveness, I think it just speaks to unreliability, and I think ultimately the fact
Going to your sister's argument, let me turn it around. Let's imagine the judge here had found that it was admissible. Would it be an abuse of discretion for the judge to have so found in view of our case law? Is this a case in which it would not have been an abuse of discretion either way?
I think so.
So if the judge had found it to be admissible under our case law, we would say that's not an abuse of discretion. Here, he found it was not admissible, and you say that too was not an abuse of discretion.
I think under the case law, this would not be an abuse of discretion either way. And I think that our best argument for it not being an abuse of discretion is State versus Chen case from New Jersey, in which the New Jersey Supreme Court, not the exact same facts, but pretty similar facts, concluded that the identification there was highly suggestive. And I think to say that, considering the New Jersey Supreme Court held that was highly suggestive, then to say that no reasonable judge could have come to this conclusion in this case, I think that it would be a stretch in light of Chen.
Can you address the independent source doctrine as to whether that should survive in view of Creighton and Gomes?
It should not survive. I think that the independent source doctrine should be eliminated. With respect to eyewitness identification, it's a doctrine that was born out of search and seizure, and I think it is easily applicable to search and seizure cases, but it's not applicable to eyewitness identification cases because the science establishes that it's really impossible to isolate where a certain eyewitness's identification came from in terms of their memory. I guess, and I think the best comparison is it's not like a search warrant where you can excise tainted information, or an application for a search warrant where you can excise tainted information and then consider whether the remainder establishes probable cause. You cannot go into someone's brain and excise the tainted identification. It's simply impossible. I would suggest that CPCS's and the Innocence Project's brief that touch more on the science behind that, but essentially, you cannot go into someone's brain and take away the impact of a prior identification that was suggestive or unreliable. It always remains there, and the taint will remain to all subsequent
But
identifications.
what if, I mean, you've got a victim of a crime who spent a fair amount of time with the accused and gives a very good description of the accused, is then unfortunately subjected to a very suggestive photo array or something of that sort, which would not be admissible because of its suggestivity. You're saying that in those circumstances, the Commonwealth couldn't establish that there was an independent, reliable source for the identification?
I honestly thought about that exact hypothetical while I was sitting down here, and there has to be a way where where the independent source doctrine could, or well, maybe we shouldn't call it the independent source doctrine, but there has to be, obviously that should be allowed. There should not be a situation where someone who's very familiar with a particular suspect is then excluded from testifying because they were subjected to a suggestive procedure. I mean, maybe it's just that better practices should be followed and suggestive identifications shouldn't be imposed at all.
We don't have to reach this question at all here, though, right? I mean, the judge found, applying it, that there was no independent source.
Yes.
But isn't there research also that touches on that very concern, the notion of familiarity as being immune to subsequent taint, and then having whatever you thought be heightened, whatever certainty you had be heightened? Shouldn't we still be concerned about notions of familiarity as being subject potentially to subjective future procedures that would actually modify what you thought you'd remember to something more certain?
Absolutely. I think that in a certain case, I mean, I think that certainly in a case where the person was somewhat familiar, I think in Justice Cordy's example, I think what I was thinking of was more so husband and wife. Clearly, suggestiveness is not going to influence that, but I think certainly...
That's not even an identification case, presumably.
No.
Is that the man you married over there?
I think so. Looks like the man I married.
But certainly, I think in an instance where the person may be somewhat familiar, I mean, I don't know what specific facts we'd be thinking of, but
Fact dependent.
yes.
All right, thank you.
Thank you.
So